Within the context of the litigation that involves Ripple and the United States Securities and Exchange Commission, the part of the action that deals with sanctions is virtually concluded. With regard to the actual penalty that Ripple is expected to pay for selling XRP to institutional investors, the parties are currently waiting for the judge to make a decision on the topic. It is anticipated that this decision will be taken in the near future. In a short amount of time, it is anticipated that the Securities and Exchange Commission will obtain victory. In accordance with the forecast, Ripple Lab has presented the court with a document in which it makes a request to maintain the confidentiality of information concerning the sales of XRP by institutional investors. The material in question is based on firm financial records as well as other private data. Ripple Lab was the one who delivered the document by hand to the court. This request is being made in response to two of the SEC points that are in direct contrast to one another. Specifically, the request is being made at this time. Ripple has been made aware of the fact that the company does not agree with two of the points that were made by the SEC in order to ensure that the severity of the penalty is fulfilled at the appropriate level. There are a number of explanations for this, and one of them is that it is essential to reveal information that had been kept secret in the past. Because of the precedent that was formed, Ripple is of the opinion that it would be irrational to release important secret financial information. Furthermore, the business feels that the request to seal some records is justified because of the precedent that was established. Ripple owes its response to the fact that the precedent was created, which established the precedent. Despite the fact that Ripple is opposed to the request that the SEC be made for more than $1 billion, this new development has still occurred. It is Ripple's contention that the contracts that were made in the past continue to be applicable to the operations of the company at the present time. According to this line of reasoning, the fact that the summary ruling was issued is the foundation. In the course of a video update on the Ripple vs. CC case, the business made the announcement that it has ceased engaging in the practice of selling XRP through over-the-counter transactions. Throughout the entirety of the video, the update was made. This announcement has been made by the corporation after the earlier announcement that was made by the corporation. A key actor in the cryptocurrency media, Zach Rector, has made the comment that the community may reasonably seek information regarding the discount that Ripple granted to some institutional investors, as well as other filing details. In addition to that, he added that the community may also request information regarding other filing details. Furthermore, he mentioned that the community might be interested in receiving extra information, which was an additional point of interest. In contrast, he asserts that companies have a wide range of contracts with their various customers, and that an agreement that has not yet been finalized would be detrimental to Ripple and the partnerships it has formed. This statement is made by him because he is of the opinion that Ripple and its partnerships are in a precarious position. As a result of the remarks that have been made by the management team of Ripple, which includes CEO David Schwartz, it can be inferred that there is transparency regarding the transactions that take place during international financial transactions. Their claim that the sales of automobiles do not have a significant impact on prices and that there is openness in the transactions of financial institutions based in other countries is something that they continue to defend. The Securities and Exchange Commission held a commission session with the intention of bringing attention to specifics and the reasons that those specifics are of the utmost significance. The goal of the session was to attract attention to particulars. Certain conditions were brought to light throughout the session, which was carried out with the purpose of drawing attention to them. The Securities and Exchange Commission first resisted Ripple's decision to redact and seal sensitive data and financial records. This opposition was initially met with opposition. In the beginning, individuals who were involved responded to this worry with disagreement. Following this, the Securities and Exchange Commission made a statement in which it said that the court needed to refuse Ripple's request to suppress data surrounding the sale of financial insecurity. The statement was issued as a reaction to the statement that they had previously issued. As of right now, there is a dearth of knowledge regarding whether or not the statement that was made by the SEC will have an effect on the decision that the court takes regarding the remedies. As a result of current events, the Securities and Exchange Commission has come to the conclusion that earlier contracts are no longer relevant. It has made some modifications to the procedures that it uses to sell XRP, which is the basis for this finding. This is the reason why it has changed these procedures. This means that Ripple will no longer use transactions that take place over the counter as a method of selling XRP cryptocurrencies. In order to simplify the procedure, this step was accomplished. At the time of the summary ruling, the court came to the conclusion that these transactions were indicative of institutional sales. This was due to the fact that they featured characteristics that were regarded to be indicative of purchases made by institutions. The sale of XRP to clients for the purpose of consumption and connection with Ripple's previous product does not include any of the necessary components of an over-the-counter contract. This is an important point to keep in mind. Among these components are discounts that are offered to counterparties that have a higher level of sophistication. This is due to the fact that this particular sort of contract does not include any of the pertinent provisions, the presence of Ripple acts as the backdrop against which the activity of selling XRP takes place. The situation that has developed is as described above. The Securities and Exchange Commission filed a complaint against Ripple in December 2020, saying that the company had engaged in illegal activities that led to the illegal funding of more than $1 billion through an unregistered securities offering. Additionally, the SEC claimed that Ripple had cooperated in these illegal operations. As a consequence of this, the two organizations engaged in a conflict that was not lawful, which eventually progressed to the trial phase in April of 2024. In light of the fact that they have collected all of the relevant information, the magistrates are currently waiting for the judge to make a judgment. This was a direct consequence of the circumstance. This is due to the fact that they have obtained all of the documents and briefs that are relevant to the case. Mainly due to the fact that Ripple has been involved in 3 significant court proceedings that took place a year ago, which caused the price of XRP to skyrocket. Some people are of the opinion that Ripple is in a stronger position to prevail in this debate. At this point, this is due to the fact that Ripple has been involved in each of these 3 court proceedings. The blockchain company Ripple, which has its headquarters in San Francisco, has submitted a letter of response in response to the request made by the Securities and Exchange Commission to seal documents that are relevant to jurisdiction and settlement plans. The recent occurrences that have taken place led to the development of this response. This long-out court battle is being keenly studied throughout the whole of the process, owing to the significant influence that it is having on Ripple and the cryptocurrency sector as a whole right now. Token sales that are conducted over the counter will no longer be used, since Ripple has made the decision to discontinue their use. This decision was made since the company is now focusing its attention on consumers who utilize its artificial intelligence platform, which provides liquidity on demand. This decision was made when the company made this decision. When making purchases, it is essential to keep in mind that Ripple does not provide any discounts to any of its customers. This is one of the most crucial things to have in mind. If this is taken into consideration, then the worries that they have about the possibility of their market being manipulated should be significantly reduced. In reaction to Ripple's statement, a legal expert named Bill Morgan stated that it is a well-known fact that Ripple lowers the price of XRP by selling substantial quantities of XRP to private investors at reduced rates. His statement was made in response to Ripple's statement. Additionally, it is a reputation that has been around for a considerable amount of time by far. A reputation that has been around for a considerable amount of time at this point. The fact that this reputation is deemed to be crucial in relation to the circumstance was mentioned by Morgan in his remark. Morgan emphasized in his statements that the organization of online direct sales is unique from that of prior over-the-counter transactions and that the new development does not have any impact whatsoever on the price of coins. This was a point that was brought up by Morgan. Furthermore, he has stated that the recent occurrence does not have any impact whatsoever on the price of coins.